Advocate Mnisi can proceed to put questions to Sergeant Mabasa on the fact or on the strength that accused number 3 never had a gold tooth, and that fact falls within the personal knowledge of the person. He does not have to be assisted by a dentist to make up his mind. He can put it as a fact, and at a later stage, it can be supported by a dental examination. And right to challenge evidence or by putting questions will also assist to challenge the accuracy and reliability of evidence that is brought by Sergeant Mabasa. Sergeant Mabasa is testifying based on his observations. There is nothing stopping to challenge Sergeant Mabasa regarding his observations. My Lord, in this court, we had an instance where evidence, ballistic evidence of Colonel Mangen, put in abeyance for almost a year to enable the defense to secure a ballistic expert in order to rebut or to challenge his evidence, which is perfectly allowed. But in this instance, the accused person wants to be examined to challenge the evidence of Sergeant Mabasa, which the source of his observation. He look at the photo and he places on record what he has observed. It will have been a different request altogether, my Lord, if accused number 3 wanted to employ the services of another analyst with the same qualification as Sergeant Mabasa to challenge whether the downloads and the photo that was flighted or beamed on the screen on the 12th of June 25 rather, is authentic or not. That would be different. But for the defense to request to determine the direction of the wind before they can make up their mind, my Lord, we submit with the greatest of respect. That is not procedure, my Lord. A version must be put before Mabasa, and Mabasa must be able to comment on that. The instructions that accused number 3 gave is not dependent on examination by the dentist. Going back to the written head, in President of the Republic of South Africa, Mr. South African Rugby Football Union, 2001 SA, the Personal Code in paragraph 61 and 63, it was stated that the institution of cross-examination not only constitutes a right, it also imposes certain obligations. A general rule, it is essential when it is intended to suggest that a witness is not speaking the truth or on a particular point, to direct the witness attention to fact by question put in cross-examination, showing that the imputation is intended to be made and to afford the witness an opportunity, whilst in the witness box, of giving any explanation to open to the witness and defending his or her character. If a point in dispute is left unchallenged in cross-examination, the party calling the witness is entitled to assume that the unchallenged witness testimony is accepted as correct. This rule was initiated by the House of Lords in Brown versus Dunn and has been adopted and consistently followed by our courts. And paragraph 63, the precise nature of the imputation should be made clear to the witness so that it can be made and destroyed, particularly where the imputation relies upon inferences to be drawn from other evidence in the proceedings. It should be made clear not only that the evidence is to be challenged, but also how it is challenged. This is so because the witness must be given an opportunity to deny the challenge, to call corroborative evidence, to qualify the evidence given by the witness or others, and to explain contradictions on what reliance is to be placed. Paragraph 6, the interest of justice. 6.1, it is respectfully submitted that it is not in the interest of justice to allow accused number 3 to cross-examine Sergeant Mabasa after the dental examination. The legal representative of accused number 3 and other counsels can cross-examine Sergeant Mabasa as they see fit, put the version of their clients. Sergeant Mabasa is an analyst. As a result, he must be challenged with the information in the XRY format, which cannot be tampered with, edited, or manipulated in any way, and by his observation of the photograph of accused number 3 depicting him with a gold tooth. Page 6.2, in R vs. Hepworth 1928 AD 265 at 277, you all know this case off by heart by now. The court held that criminal proceedings are not a game in which one side is entitled to claim the benefit of any omission or mistake made by the other. The duty of a trial judge is not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice was done. We submit, my lord, that justice will be served by not allowing the Sergeant Mabasa to be cross-examined only after accused 3 has been examined by both the state and private dentist. 6.3, in State vs. Sheikh and others, CC, I've already cited this case. 2007 Constitutional Court decision, also reported 2008, Volume 2 SA, Constitutional Court. And the court held as follows: the applicant stresses that they place their reliance on the general right to a fair trial, which, as this court has dealt, extends beyond specific rights enumerated in subsection 35(3)(a) to O of the Constitution. The right to a fair trial requires a substantive rather than a formal or textual approach. It is clear also that fairness is not a one-way street, conferring an unlimited right to an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state, must instill confidence in the criminal justice system with the public, including those close to the accused, as well as those distressed by the audacity and the horror of the crime. On emphasis added. In multi-choice property limited and others versus National Prosecuting Authority, and another 2014 ZAGPHPC 37, also reported 2014, Volume 2, all SA reports. Decision that comes from this division. As Kemelambo, JA held that our constitutional court has been vocal regarding the protection of the right to a fair trial. Indeed, any accused person who appears in a court of law facing any charge has the constitutionally guaranteed right to a fair trial, which includes the foundational values of dignity, freedom, and equality, which are central to a fair trial. In this regard, the Constitutional Court in State vs. Zukuda and others, and State vs. Chilo, confirmed that the right to a fair trial is a comprehensive right and embraces a concept of substantive fairness, and that at the heart of the right to a fair criminal trial, what infuses its purpose is for justice to be done and also seen to be done. B. In State vs. Lamini, State vs. Ratha, and others, State vs. Joubert, State vs. Itekat, 1999, Volume 9, SACR, page 51, Constitutional Court, also reported 1999, Volume 4, SA, 623, 1999, Volume R, BC, LR, 778, Krikla J. Describe the phrase interest of justice as a useful term denoting in broad and evocative language a value judgment of what will be fair and to all concerned. All emphasis. Paragraph 6.4. It is therefore respectfully submitted that the application by the accused number 3 be refused. As a copy, please.
Yeah,
my colleague just did receipt. Furthermore, Mr. Ramos Sepile on his paragraph 2.1 of his written heads of arguments also made mention of section 37 subsection 3A of the Criminal Procedure Act, my lord, and we submit, my lord, that the section 37 subsection 3A is not applicable. It strictly refers to taking of fingerprints and bodily prints, and we request the court not to also consider that.
Submitting that the analogy of that case, the court of justice may consider it.
Indeed, so my lord. If then the court consider that by all means accused person can be taken for examination.
But that case, okay,
yes,
relates to a witness, is that so? Sorry, not a witness, an accused person.
Yes.
Who refuses that this fingerprints must be taken?
Indeed, so my
That's a
lord.
distinction. You see, he's using his own will, free and voluntarily. And he says, no, I won't let them take my fingerprints. I don't want them to be taken.
Yes.
Now the court is taxed to decide this, because the law actually makes provision for fingerprints to be taken using reasonable force. What section is it?
37.
Pardon?
Section 37.
37, my lord.
Section 37.
Yes, I'm saying the law empowers the court to instruct the court order, for instance. We take the number of these fingerprints using reasonable force.
That's so.
Why? This is not different from.
It is different from what we are dealing with at this
Is
time.
that okay?
That's
Going fine.
Furthermore, my lord, Advocate Mnisi during his address indicated that he does not know the aim of the evidence that the state tenders. However, Mr. Ramos Sipili answers him on paragraph 3 of his submissions, and he says the aim of recalling Sergeant Mabasa was to introduce photographs depicting accused number 3 with a gold tooth incision. The allegation that one of the intruders at the Kumalo household on 26 October 2014 had a gold tooth. It is with this in mind that Mr. Ngube makes an application for his medical examination to rebut the allegation against him. So, when did this evidence that one of the intruders had a gold tooth, then we go back to the evidence, Exhibit J. And if I recall very well, the first counsel to introduce Exhibit J in this proceedings was Advocate Mnisi, going through what Taban Makilini said regarding one of the intruders, and then it was also said that one of the intruders had a gold tooth. That's how it started. And then we can pull the record, yes, that's how it started. And there's no way, even during first examination of Brigadier Gininda, where Advocate Mnisi puts it to Brigadier Gininda that accused number 3 never ever had a gold tooth. Gininda was just asked to go through the photos, to identify, to give descriptions, and that we see on the proceedings of the 29th of November 2014. And I'll just read the passage. And this was what was Advocate Mnisi saying. But having said that, let us go to Exhibit S. You take us through these photos. Those downloaded photos that you were taken by accused himself with dreadlocks, big eyes, with golden teeth. We can request the stage for us on so that the accused persons can also follow. Start with the first picture. That's how this issue started. And it was never disputed or Guinea being challenged on this fact that accused number 3 had a grade 2. It's only now when I made an endeavor to lead such an evidence that accused number 3 wants to be examined by a dentist to assist him, my lord, to proceed that we submit that cross-examination of the witness can proceed without him being sent for oral, for examination by the dentist. And the point is not one of procedure, but it's one of following established rules of cross-examination.
Yeah, but then Mr. Mnisi says he has not consulted his client. Am I correct? Let me continue, Mr. Mnisi. You're saying, I have not been able to consult my client. I have not consulted my client.
That is correct. That is correct.
But Mele, just to also add on, Mr. Numalo also indicated the photos are in excess of 5,000 photos. I think he's mixing the photos. The 5,000 plus photos that are for accused number 2. With accused number 3, it was plus minus 700 photos. And then I submit my lord before this court. Those photos are voluminous, and it was only then when Advocate Mnisi requested a postponement to prepare cross-examination on behalf of accused number 2, that the state as well as the investigating team were able to sit down, go through those photos one by one. It was not a very easy process, my lord. It took some time for it to be. So it's not correct that we said with the evidence. The evidence was discovered to the defense. I think after the 1st of August 2023, after the evidence of Sergeant Mabasa, all the photos were given to the defense. The defense are in possession. Even that specific photo that is a subject matter before this court.
I was updating that on the 1st of August 2023. Those photos were in existence already.
They were in existence. Just that
where were they? Or where were they procurable?
My lord, I remember in that during that period that we have to adjourn. We went to our offices, we sat down with Sergeant Mabasa, and then we went through those photos, and certain additional photos were also selected. And we further discovered the whole band USBs that Sergeant Mabasa copied and handed each and every defense counsel. And amongst the photos that we handed in is the photos that we introduced or last week through Sergeant Mabasa. So the photo has always been there.
Okay, fine, it's a misnomer, but the pertinent question is, if the state was not aware of this evidence before the 1st of August 2023?
No, my lord, we're not aware of this specific photo they pulled to.
And that particular photo was not self-standing. You understand what I'm saying? It wasn't self-standing like this. And
it's part of a bundle, my lord.
yeah, it wasn't self-standing. And let's just show this video. Like so.
Yes.
It was out of the bar.
Let me understand the court. The photos that we were provided on a PDF document.
Now that I'm aware of, and then they were downloaded.
Yes.
And then Mabasa says the pigmentation of the photo wasn't bright.
Yes.
That's why you use software.
To just add lights.
Listen,
That's correct.
but what's intriguing, if they were not visible to the naked eye after being downloaded from the
SD card.
the device, yeah,
Yes.
they were not visible. This, I think they were not. This one was not visible.
My lord, it depends. Let me explain to you the
Don't run away
court.
from my question.
No, I'm not running away from the court's question. I'm saying, my lord,
Was it visible to the naked eye, or was it not visible to the naked eye?
it was visible on the naked eye when we went through the photos one by one.
Yes.
Yes. If you scroll through the photos,
Yeah.
you won't be able to pick it up.
Yes.
But if you then sit down, take your time, and then you zoom in and out, then you'll be able to pick it up. But if you're going to rush into looking into the photo, then you won't be able to see. And I can also mention, my lord, from the photos that I personally went through of accused number 3, I think that is the only, if not, I'm under correction, my lord. Okay, I just had my colleagues. Let me just type it here, my lord. I wanted to make another submission, but take it up during.
Maybe.
I'll be accused of testifying, my lord.
I was still going to maybe ask questions regarding your answers.
I'm saying it's one of the few photos
Yeah.
that one can see the accused person smiling.
Oh.
From the ones that I have seen personally, out of the 700 photos, I cannot recall them, but it's one of them that stood out from that particular photo. That's quite possible. And it has to be enhanced, my lord. That's what I'm saying. It has to be enhanced. And it was not a one-day process. I have to, at some stage, look into the photo and then go home, come back tomorrow, print, look into it, then.
And this is a probable question. Does the accused have the mechanism and the means and the equipment to enhance the photos? I'm not talking about his lawyer. Talking about the accused.
No, the accused does not have.
And without any technical assistance, you will never get. And I'm speaking like he is not represented. You will never get the photograph to come to this perfection. The expertise.
I'm not sure.
You don't understand it.
I understand what they call them.
Oh.
What they call the saying.
Yeah.
Just that I do not know his level of
No,
understanding.
he's not at the level of an analyst.
But I can also do that, my lord. But I'm not an analyst.
Yeah, but I just want to pierce through.
Yeah, if he can have a laptop and then the photograph, surely he can zoom in and out because the function that is readily available on PDF as well.
If he doesn't have that,
If he does not have that, that's why we prepared that document where it zoomed in.
right? So you see this 3 years, 3 months before he testifies against a witness who alludes to the existence of this photo.
Our point of departure, my lord, is the question whether he had a gold tooth or not is something that falls within his personal knowledge. If he sees it and he says, I never had a gold tooth, I think for me that is enough. Then the cross-examination of this witness can proceed, and then it can be put to my boss that you edited this photo, you manipulated this photo. I never had a gold tooth. Don't have to go to a dentist to confirm whether you had it or not. It's something that falls within his personal knowledge. And that won't change me.
But what does the fact that this counsel says he never could consult with his client Because he said he wants a dentist for the professional to give an opinion.
My
Of the
Lord,
vote.
by all means, you can go and get an opinion.
Then after,
Yes, but the witness that you are dealing with, the one that is on the stand is Sergeant Mabas, an analyst.
yeah, fine.
It won't change the fact that accused never had a good tool. Then that will be the second part of his right to give and to adduce and challenge evidence.
Okay.
We will have already challenged Mabasa on his findings, and then later on, during his case, he can adduce a report, which is perfectly allowed. But it would be unfair for him to first determine the wind, the direction of the wind, so that he can make up his mind. It would be unfair for the witness, it would be unfair to the state. And furthermore, what is important, the court asked few interesting questions to the other witness, warrant officer, regarding these observations. To say, do you use spectacles? Are you able to see there? And I think that deals with the issues of observation. And that's what Mabasa is also here to testify about. What Tabang Makeleni saw on the 26th of October is also observation. And what is there? Let's go, please.
Maybe nothing. Mr. Mnisi, from the defense, who wants to edge on.
As it is the court, my lord, I'm going to be very short. I do not hear the state talking about that we are misapplying the provisions of section 35(3)(b) when we request that an accused should be afforded the opportunity to prepare his defense, my lord. And with regard to enough opportunity and facility to prepare his defense in order to challenge the state's case, the state does not address that. Number two, the state is also missing the aspect of a prejudice. I haven't heard them saying that any other person or any interested party in these proceedings will be prejudiced if accused person were to be afforded this constitutional imperative, my lord, for him to go and prepare his defense and have all the necessary amenities to prepare such. But another point, my lord, that is being raised by the state is that I cross-examined Makeleni and specifically put to him or her, I can't even remember whether it was a woman or a man, that accused number 3 had a golden teeth. I think that is mistaken. I never cross-examined any witness who was... Yes. So, but that's what the state is saying. So, but as I'm saying, I never cross-examined a witness who purportedly was called by the state who came to testify about them being around the scene. It is only one witness that I cross-examined, the witness who was seated in the Morovia High Court. But those who were in the house and all those who made statements, I'd never cross-examined them. Now, the state is further saying that we're not offering any reason why we're making this application. I don't know what is the thinking of the state and what is the basis of saying that. But let me quickly say that it is not a flimsy request. The state does not dispute the fact that for almost 10 years, the investigating team had these photos. And for almost 5 years, the prosecution team had these photos. And on the date on which the photos were handed over to us, which is in the month of April 2025, the state does not dispute the fact that they never mentioned that the reason why we want to introduce this evidence is specifically because we want to demonstrate that at the time of the commission of the offense, accused number 3 had a golden teeth. They never mentioned that reason, my lord. Had they mentioned that reason, I would have actually made it a point that thenceforth, I deal with the aspect for the purpose of of the new evidence that is being introduced to demonstrate that accused number 3 had a golden teeth. It is only during the testimony of Mr. Mabaso that, as I've said, we're shell-shocked to learn that accused number 3 had a golden teeth at that time. That was the first time that we came to know the purpose for which the state actually led this evidence for. And for the state to say that it doesn't matter, we can as well put our version even if we have not thoroughly prepared for the evidence of Mr. That goes against the Constitution, my Lord. Look, I need to be very honest with the state. Our cross-examination is structured. Our cross-examination is found on certain basis. Our cross-examination is just not a one-ton cross-examination, my Lord. And there's authority, I'm just missing that case that says that a cross-examiner should be wary of putting information to a witness without verifying the authenticity of that information, because it will be very difficult for the cross-examiner to withdraw that information or that suggestion upon upon them finding out the real nature of things. Mr. Ramusipili indicated that what we are requesting can go either way. It can be in favor of the state, it can be in favor of the accused. So if the accused says, no, I request that I should be given an opportunity to be assessed before I come and cross-examine this. If information comes out and say, no, but accused person, you dug your own grave, then you can go inside it, then let it be so. But the state cannot say, no, the defense must do this even before they are not ready. How can I proceed to put on questions to Mr. Mabaso when I am not ready to do so? And I've indicated to the court, my Lord, that would be a misrepresentation of what I'm sending for here, which I solemnly undertook that I'll do the best that I can to conduct accused number 3's defense in the best possible way that I can, my Lord. Now, this in the larger part of what is contained in the defense's heads of argument, my Lord, there's nothing that is in dispute between the state and the application that accused number 3 is bringing. All that the state wants, it says, no, Mr. Mnisi, continue to cross-examine Mr. Mabaso, even if you do not have that information that will enable you to cross-examine him with. But I am saying to the state, I am not in a position to do that because I want this information. And an accused person has got a constitutional right to get that information, my Lord. So I've quoted at length the values that are enshrined in the Constitution in terms of what a fair trial is. I've said accused person does not ask something out of the ordinary. He's basing his request on the Constitution. This is a constitutional imperative than a procedural requirement, my Lord. I would therefore submit, my Lord, that in my response, that in the greatest analogy of things, I don't think that state and accused number 3 are far apart from each other, except the fact that the state says, no, you can cross-examine, and I'm saying I'm not ready. And if I'm not ready, I don't want to prejudice accused person's place. I would therefore request, my Lord, that my state of unreadiness was not a self-made state of unreadiness. It's a state of unreadiness that came as a result of what the state did, their failure to disclose to us this information when they already had it for 5 years and 10 years simultaneously. The group that represents the state had this information for 15 years. And Mr. Sibanda says that they had to go for more than 5,700 photos, my Lord. That is not entirely correct, my Lord. Look, we are here on the case of accused number 3. There are 700 photos that they had to go through. 700 photos that they had to go through in respect of accused number 3. And out of those 700 photos, there are photos that are women photos, children photos, church photos, firearm photos, car photos, and all those photos which have got nothing to do with accused number 3's teeth. There are very few photos that are contained in those 700 photos that would denote accused number 3's dental formula. So it's not like the state had to take for more than 5 years only to identify 1, 2, 3, or even 4 photos where accused number 3 dental formula is visible for them to come to a conclusion that as and when he allegedly was part of the commission of the offense, he had a dental formula. I think that is a gross misrepresentation of facts, my lord. They are just trying very hard to give a reason as to why, up until the testimony of Warrant Officer Mabaso, we were not appraised of the fact that his evidence would be to demonstrate that Warrant Officer Mabaso had a golden tooth at the time. And there's also a misnomer in what the court is being told. It is suggested that through my own eyes, I found information from Brigadier Kininda. Actually, I put to Brigadier Kininda that indeed accused number 3 had golden teeth, had a white alabaster of skin perfection, and had dreadlocks. No, that did not come from me. Brigadier Kininda, when he applied for the warrant of arrest of accused, I think that was in Exhibit J, if I'm not mistaken, he mentioned amongst others that the perpetrator, who was a gun-toting perpetrator going to the house, had those features. I was taking him through what he said in his affidavit when he applied for a warrant of arrest, and then I further requested him to say, okay, this is what you told the magistrate. He said yes. Can we then go to Exhibit S and determine these features which you said the gun-toting perpetrator had them? It's not like it is the defense that says accused number 1 had those features. I think that is grossly misquoted, my lord. But in the larger part of things, I will still stand by our argument that the accused has been able to make up a case that at least he should be accorded this constitutional imperative, this constitutional right to be allowed to prepare himself for the cross-examination of the evidence that the defense was shocked with when Warrant Officer Mabaso testified, my lord. I would request that the court find in his wisdom that he should be afforded that constitutional requirement, my lord. Thank you, my lord. That will be my response.
As the court pleases, my lord. My lord, just a short one. At paragraph 6.1 of the state's heads of argument.
6.1.
Yes. It reads, Sergeant Babasa is an analyst, and as a result, he must be challenged with the information in the X-ray format, which cannot be tampered with, edited, manipulated in any way, and by his observation of the photograph of accused number 3 depicting him with a gold tooth, my lord. My lord, part of my cross-examination and Ms. Mishololo at the end to Warrant Officer Ndlovu was to get a concession. The metadata and especially photographs can be edited, can be manipulated, can be tampered with. He made that concession, my lord. The last question of Advocate Mishololo. So that is not correct to say this cannot be edited, manipulated, altered in any way. That's of argument, my lord. That's the court process.
Thank you, my lord. I have nothing further.
I have no submissions.
Yeah, tell me, are we going to work during recess?
The state is available.
Are we going to work during recess?
My lord, I'll speak for myself. The longer I'm in this case, my practice is collapsing, my lord. I need to service other clients.
My lord, I'm already committed in other cases now.
So you're not available?
I'm not
I'm
available.
not available, my lord.
You say you're not available?
I'm not available, my lord.
Okay, Mr. Lumano.
I am available. I am available.
Okay, that's okay.
As it is the court, my lord, this for obvious reasons, my lord. Look, I had to start to prepare for the cross-examination on behalf of accused number 1 to Brigadier Kininda, and I had to go voluminous pages. When other colleagues of mine and everybody else had their fair share of rest in the first stanza, when we closed for the first session period, I had to go and read, my lord. So I have had no time to rest. I am very exhausted, so I don't think I will be available in the recess, my lord.
You're not available?
No, I will not be available. Yes, my lord. I need to go and rest.
You are going to be an order now, and the reasons will follow. And let me say, at an appropriate time. I never do that. Deliver the ruling or reasons. Order, without giving an order, but in this case, we have first the time. See, the first 4 weeks already now, because some persons are not available. It's only the state and the remand who are available. Okay, so the order I grant is the court finds that accused number 3's counsel has shown on the probabilities that is persuaded this court that could possibly be an instantaneous refusal or denial of accused number 3's rights as he understands them. I'm not dealing with a ballistic expert. He says, it's not persuasive. He says, if it's not represented, him alone, he would never know how to decipher these photographs. Whether to enhance them, etc., etc. So for those reasons, give him the benefit of the doubt that. What's that?
I'm tripped over the wire. Sorry.
Oh, sorry. Yeah, so what the order is, consent is accorded to accused number 3 and please consent to consult, as they say, what, a dentist or what? A dentist or a dental practitioner of their choice. Right. So the next thing now is, when will the examination by the dentist take place?
As it is the court, my lord, basically, we're not saying exclusively by a dentist of his own choice. Remember, accused number...
It has to be his own choice. You said that, I was listening to you. Now, I think you're saying the state must do it. That changes the dynamics. Because you are listening to the argument of the state. They say the client has the right, or the constitutional right, to do it after you have conducted the cross-examination.
It is fine, my lord. I will have to take it up with the...
No, you can apply for legal aid if your client is not having the financial means to do that.
Yes, my lord. But on the same breath, I'll have to take it up with the correctional services who are responsible for his custody and arrange with them those dynamics, my lord. I can only hope that they cooperate, because if they don't cooperate, then that is going to further delay this process. Because I may just mention that as early as Friday, I had already started to talk to them. I wrote to the legal advisor, one of the ladies who was here, when we're applying for, or when we're arranging the process to apply for the challenge that he had with his incarceration in solitary confinement. I haven't had a response. At lunchtime, I asked her what the developments are. She said to me she has not received anything from the superiors there, correctional services, but she will follow. So my intuition is telling me I might be met with a bit of a resistance, but let me put it on record that resistance, wherever they are, if they are listening or if they are able to hear, or members of the correctional services are here, and one is responsible for accused number 3, that resistance will not be in the interest of administration of justice, because I am saying, my lord, that my intuition is telling me that possibly I could be met with a resistance in being assisted to have accused person referred for a dental assessment by an independent orthodontist or a dentist, my lord.
Okay, let's take this route so that it makes sense.
Yes, my lord.
Mr. Dr. Sibanda, will the state pay for this? Will it be willing to pay? Because this is the first time in
It's for the first time, my lord. It's for the first time. I mean, with the state, there are state dentists that we can use, but if he wants to use his own, then you have to pay.
There have been 2 cases like this, where I paid out of my own pocket. That case was in 15 years back. The accused person started writhing, as if he's eaten poisonous food or whatever. We adjourned. I said he must phone the district surgeon. They phoned the district surgeons at the time. There were only 2 district surgeons available in Johannesburg. They told us that these gentlemen are out of town on a particular errand. Then I spoke to the prosecutor. Can we take this gentleman to Counsel Senzo, because I knew that there's a physician there. Then your colleague then told me, no, you need 3 quotations. You must submit 3 quotations, and then you take the department to take the least expensive quotation to pay. How long will that take? As we don't know, and the guy, I didn't know, the rest is dying. So I phoned this gentleman, who's a physician, to come to court and attend to this gentleman who was writhing on the floor, being sick or ill, and vomiting. They attended to that exigency, and I paid out of my own pocket. Then I got flat, as I usually do. Hey, the way you want to convict our clients, we have appeals to buy some of the hotels. I never claim that money there because the regulations don't make provision for it. So let's be clear. How are you going to finance it?
Well, I think on the last appearance.
No, I want the state first to tell us because your client is available to you.
My lord, the state can assist him with the state dentist.
State?
Dentist, the one that works for the state.
Are you prepared that the state dentist? That's what we said. You will fabricate things.
I'm the last one to say that, my lord, because
I've been listening to fabrication all along. Telephone numbers are fabricated. Fingerprints, and those fingerprints. What do you call it?
Probably the DNA results as
Cell
well.
phone numbers are fabricated, etc., etc.
Yes, ma'am. As I'm saying, my lord, I'll be the very last one to say that because I know Mr. Meyiwa, as of now, is in the care and custody of the state. So the first point of reference when issues of this nature arise is for him to refer to a district surgeon.
Okay, fine.
It is only in extremely extraordinary circumstances where he can be taken out of the perimeters of those who are holding him and be referred to a private practitioner.
However, we can make an order. So,
Thank you, madam.
so there's no problem if the district surgeon who feels a J88 attends to the private.
I definitely have no problem, my lord, but it should be a surgeon who has got a particular expertise on the field of tea.
How will I know?
I think there are dentists who are also working for the state, my lord, who work with the district surgeon. Remember, a district surgeon is just an institution. There are pediatricians there, there are oncologists there,
Yes, you're
there are
right.
orthodontists there. There's everyone, my
You're
lord.
right.
Yes,
The district surgeon there, if he sees that you need an amputation,
yes,
you recommend the surgeon,
yes, my lord.
the
Yes,
physician, the
yes.
orthodontist or whatever.
yes, yes. But then the first point of reference would then be a district surgeon.
Wait. That was a problem.
Yes, my lord.
So you're trying to make use of state facilities because here you said to me you're trying one for the state, one practitioner who's employed by the state, and another one apparently who's in a private practice.
Let me clarify the position with him, my lord, because I don't want to speak on his behalf.
Yeah,
I can
find out.
only carry out instructions, my lord.
Eseza kuwena ubaba Mnisi, inkundla ivumile mfethu ukuthi ke uhambe uyobona nodokotela. Manje umbuzo ukuthi ke uzosebenzisa umbuso noma ofunwa uwena.
It's a matter of interest. I don't know if you remember the sentence. I listened to evidence in this court, somebody saying, it's my brother who has a tooth, a golden tooth, and not my other brother. You remember the sentence?
I remember my lord.
If you can follow it, you get the name of the other brother who's got a golden tooth. And you may be able to tell you where you can eat this other brother and find solace.
Yeah, I recall the evidence, my lord. It was during the cross-examination of Brigadier Gininda as well.
Yeah.
The name of the brother is Wazinkosi or something.
Yeah, challenge it with Mr. Mnisi. Because apparently there's another brother. Let me just say another. There's a brother who has a golden tooth.
As it please the court, my lord, for indulgence, I think Mr. Meyiwa is being brutally honest here. He says, on account of the fact that there are so many things that have happened in this trial, he has totally lost confidence in the state machineries. So he would prefer that the court makes a directive that he be seen by a private practitioner who's got knowledge on dental formulas. That is what is coming from here.
Futhi ke impendulo ebuya kuwena Mr. Ncube ukuthi nje uzokhuluma ke iqiniso la ukuthi ke ngokungathembi kwakho ke umbuso usucela inkantolo ukuthi ke ikhiphe ke isinqumo sokuthi wena uhambe uyoyibonela nje udokotela ke oyimele, awufuni ke ukuthi uyobona ongaphansi kombuso.
I suggest, my lord, that we may adjourn for now and then come back tomorrow. I think I would have a clue, because another thing he's asking me as to how much would be the cost implications be, and I'm saying to him, I never had dental problems. My teeth are still, I think they're 38 or 35 in my mouth. I never had a problem. So I specifically don't have a clue as to how much the cost implications will be. But if we can adjourn up until tomorrow, I think when I come back, I would be having a bit of information as to the amount at which the private practitioner would cost.
So he doesn't want a state practitioner.
He says, on account of the fact, yes,
He doesn't want a state practitioner.
he says, my lord, he's very cautious. He's very cautious.
Is it possible, Mr. Babu, is the doctor? I want to find out. If tomorrow we can report.
This knowledge we left to inquire and report back tomorrow. On Thursday, because it's amendable.
Yeah, but then, because of the problem, because the other answer is not available. It means, during this week, we have to fix something concrete. And then we postpone. The witness should be available so that we can continue with the
But we can reconvene on Thursday with the feedback.
Is that okay? Thursday.
It is in order.
It's in order, man.
Okay. Come back on Thursday.
Sasa ngalazo ngolesine lapho thola khona impendulo.